My warm wishes to all the viewers and subscribers of KCGC TV. I am Richa Joshi and I work as Assistant Professor at Khalsa College of Law. Today I will talk about the Doctrine of Precedent. A precedent is a judicial decision given by a court of competent jurisdiction over a disputed point of law. It is not only a guide but also an authority to be followed by all the courts of competent jurisdiction that have subordinate status, and it not only has to be followed with the binding effect, and it works until it has been overruled either by a statute or by a court of competent jurisdiction. It has to be adopted or taken as an example by all the courts which are subordinate to the court higher than it. In the realist school of jurisprudence, the doctrine of precedent holds utmost importance because in this school, the lawmakers are judges and the judge made law is the only law. In this school, it is considered that the decisions given by the judges are based on practical experience and human factor of the judges as well as the lawyers. So, it has utmost importance among the jurists such as Hegel, Axel Hegel-Strom, and Oliver Crona. Also, it holds great importance in the Commonwealth legal system. So, it has high importance in Indian law as well as English law. But the continental countries give more importance to the legislation. So, as in natural law school, the god or supernatural forces have highest importance as a source of law. In the sociological school of jurisprudence, the will of the society has the importance as a source of law. In analytical school of jurisprudence, will of the sovereign has highest importance as the source of law. Similarly, in realist school of jurisprudence, the judgments or the judge made law is considered the most important source of law. Back in the time when customs and justice notion were at their zenith, the court's decision had the utmost importance. As per their discretion and understanding, they used to decide the cases. And with the development of legislations, the role of the courts changed with time. Their role was now the interpretation of law and as well as filling the gaps in the law which were prevalent at that time. The groundwork of the doctrine of precedent has been laid down under Article 141 of the Constitution. According to this article, the Supreme Court can, whichever decisions have been laid down by it, are binding on all the courts of subordinate jurisdiction throughout the country of India. However, the decisions of Supreme Court are not binding on itself. In the judgment of Bir Singh versus Union of India, it was laid down that a judicial decision is a precedent when it is binding on all the contingencies of similar facts and the point of law. And it becomes binding when there is a rationale that has to be followed according to which the decision has been laid down. A judgment has mainly two parts which depend on the doctrine of precedent, and these are the ratio decidendi in English, and in Latin it can be said as ratio decidendi, and the other part is obiter dicta. Ratio decidendi is that part which is binding and comes under the doctrine of precedent. It contains the rationale based on which the decision of the court is laid down. In the case of Jayant Verma versus Union of India, it has been laid down that a ratio decidendi is that part which is given on the basis of giving hearing opportunity to the opposite party, by giving proper rationale on which the decision is based, and citing proper case laws to justify the reasons of the decision. On the other hand, obiter dicta is that part of the judgment which contains either the judicial opinion, the suggestions given by the court, or the observations made by the court on the society or any point of law. So, out of both the parts, ratio decidendi is the binding one, and obiter dicta just has persuasive or suggestive value. There are four types of precedents: original, declaratory, persuasive, and authoritative. The original precedent is that one which gives an or establishes any original legal concept or precept. According to Austin and Friedman, it is the only kind of precedent that is binding, as it has the law making role of the judges. The other category is declaratory precedent. Declaratory precedent just reiterates, repeats, or applies an point of law or legal concept that is already established. According to Sir William Blackstone, it is the only kind of precedent that is binding, because, according to him, only duty of the judges is interpretation and discovery of law. The third category is persuasive precedent. Persuasive precedents do not have any binding effect, they have persuasive value. The courts or judges can adopt such decisions or accept them upon their discretion if they find them appropriate and good enough to be applied by them. There are many types of precedents which have persuasive value. Just like foreign judgments, the obiter dicta of any judgment, or a judgment of a high court for another high court, and it can also be the decisions of the tribunals. The last category of precedent is the authoritative precedent. These are the decisions of the court which have to be accepted by the lower courts, irrespective of the fact whether they accept or agree with those decisions or not. They have to apply those decisions in their judgment no matter what, and these are binding on them. There are two categories of authoritative precedents. Authoritative precedents can be conditional or absolute. Conditional precedents can be avoided if they are not good in law, and absolute precedents have to be applied even if they are bad in law. Coming further, there are some basic principles of the doctrine of precedent which are to be followed by all the courts. The first one is that the precedent is binding on all the lower courts. They have to follow and apply those decisions irrespective of their opinion. In the case of J. Sharma Rao versus Union of India, this fact was established by the Supreme Court. The second principle is that a decision of one high court is not applicable as a precedent on another high court. In the case of Pillai versus Pillai, this fact was established by the Supreme Court. The third principle is that the decisions of Supreme Court are not binding on itself. The Supreme Court is free to review, revise, and reconsider its decisions. This has been clearly laid down in Article 141 of the Constitution and was acknowledged in the case of Bengal Immunity Community versus Union of India. The fourth principle is that when there are different decisions given by two benches of coordinate jurisdiction, the later decision has the binding effect, and the authority of decision increases with the increase in number of judges in the bench. The next principle is that a high court's decision cannot be overruled the decision of Supreme Court. This was laid down in the decision of Sugandhi versus Jagdisham. But however, on the other hand, the Supreme Court has the authority to seize the binding effect of a judgment of High Court. This was laid down in the case of Pandurang versus State of Maharashtra. Next principle tells that there are some conditions which have an effect on the binding value of a decision. These can be decrease the value of precedent, and these include a part of obiter dicta which already do not have any binding effect. And if any case does not consider the rational or is devoid of any reasoning, then it loses its binding effect. A judgment can also be ignored if it ignores the central crux of the case. And if a judgment is sub silentio, that is, if it is given by ignoring the central point of law that had to be decided by the court and is passed without any merits, then it is called sub silentio and has no effect as a precedent. Next says that a judgment given per incurium, that is by ignoring the law. If by ignoring the law a judge has passed any decision, that it does not need to be followed as a precedent. And last, mere directions or suggestions of the court cannot have a binding effect. Then we can consider some advantages and disadvantages of the doctrine of precedent. There are many advantages, like it saves the time, sources, and avoids the unnecessary litigation. It also helps to maintain the consistency of the legal system, which helps in good decision making. Next, it can also be helpful in the interest of justice to make the laws certain. And there are also chances of making less mistakes and avoiding the arbitrariness in the decision making process. But wherever there are advantages, there are disadvantages also. So, their practical experience of the practice of law is hampered because it limits the scope of the practical practice in the courts. Another thing is it sometimes makes the system rigid, and there are also chances when the mistakes made by a higher court have to be blindly followed because those are bad in law. So, this is also known as the concept of stare decisis, which talks about the binding effect of the law that is laid down by the courts. It has to be religiously followed by all the subordinate courts like a rule of law. And this system has helped in development of many different important laws in India. The doctrine of precedent has thus helped in development of many laws in India, just like the case of Keshavananda Bharti versus State of Kerala, Navtej Singh Johar versus Union of India, Joseph Shine versus Union of India, and many cases which have helped in expanding the scope of fundamental rights in India. So that was all about the topic. Thank you so much.